extreme. Take a look.
All right, as to instruction number 3, aggravating circumstances, you have circled either yes or no for each aggravator. As to the first potential aggravator, that the offense of murder was committed while the defendant was engaged in the commission of burglary in the first degree, you have circled yes. And as to the aggravator that the offense of murder was committed and the defendant's act or acts of killing were intentional and resulted in multiple deaths, you have circled yes and signed instruction number 3. Is that correct?
It is.
As to verdict form A, count 1, murder. We, the jury, fix the defendant's punishment under count 1 for the offense of murder at life without benefit of probation or parole, and you've signed that, correct?
Yes, sir.
Count 2, murder. We, the jury, fix the defendant's punishment under count 2 for the offense of murder at life without benefit of probation or parole, and you've signed that one.
Yes, sir.
Count 3, murder. We, the jury, fix the defendant's punishment under count 3 for the offense of murder at life without the benefit of probation or parole, and signed that verdict form, correct?
Yes, sir.
Court TV crime and justice reporter Joy Lim Nakarin was in the courtroom and in Elizabethtown, Kentucky, and has more for us tonight.
You know, the emotions still very raw today for both the victim's family and the defendant's family. Of course, the victim's family really expressed such a sense of relief, and that continued on today. Whereas the defendant's family, initially, when that verdict came down, they appeared to be in utter shock, complete disbelief. Today, it was as if, you know, this new reality has set in. They've accepted this dim prospect that their lives with their loved one will forever be changed. And, you know, really there was a sense of acceptance and hopelessness, I would say. Yet the defense team continues to insist that Christian Martin is innocent, and you've got the wrong guy. And you can see that with the defense family members and loved ones. You know, there is still this sense of a heartbreak because they seem to genuinely, in their hearts, believe that their loved one is innocent. Back to you.
Joy Lim Nakarin in Kentucky for us tonight. All right, let's get more reaction to this verdict and verdicts, actually, because they're both verdicts. The sentencing was a verdict as well. Let's bring in our think tank. Joining us tonight in the Bronx, New York, criminal defense attorney Renee Hill. In Atlanta, Georgia, family law attorney and law professor Randy Kessler. And also in Atlanta, Georgia, criminal defense attorney Michael Bixon. Great to see everyone tonight. I want to play for you Tom Griffiths. He's the defense attorney for Kit Martin, the convicted triple murderer who will spend the rest of his life in prison without the possibility of parole, who spoke with Julie Grant earlier today. Let's take a listen.
The verdict in this case really amounted to misplaced blame disguised as justice. I think we had 12 jurors who felt terrible about the 3 people who had been murdered. And the only person they could blame, the only person in the courtroom they could look to try and reach some sort of justice was Christian Martin. And that's what they did. Not based on evidence that they'd heard in the courtroom, but based on their desire to give a result.
Renee Hill, you know, the way he says it, it's almost as if whoever was on trial was going to be found guilty, regardless of evidence or lack of evidence. But, I mean, he kind of skimmed over some of the things, like the testimony that, yeah, listen, Kit Martin wants to kill me. If I end up dead, make sure you take a look at him. I mean, that's part of the evidence, the 45, the crazy story about the setting the alarm at 1 o'clock in the morning. And, oh, yeah, he testified. They didn't believe him.
Yeah, Vinny, the prosecution's case was very weak. I thought that the defense attorney did an excellent job here. I thought that they were able to pick apart the prosecution's case. But at the end of the day, I said this a couple of days ago to Ted Rowland. I said, I would not put this defendant on the stand. And I think that by him taking the stand, he undid everything that his defense team established on his behalf. He ruined it for them. He was too cocky. He was answering questions that weren't put to him. He was making legal arguments in the answers that he was giving, and he just was not a likable person on the stand. So I think that even though the defense established doubt in this case, the jurors didn't like him, and for that they wanted justice for the victims in this case. He was the defendant in that chair. They didn't like him when he testified, and they found him guilty.
I didn't like him either, Randy. And after he testified, Julia Janae told me on the air, because, mine's the last show of the night. Just like Renee Hill, Julia Janae talks to the other anchors on Court TV. And she said, Vinny, you're the only one. You're the only one who didn't like this. And I'm not the only one. There's 12 other people who didn't like his testimony, Randy.
Yeah.
Well, that's sort of what's interesting, right? You think when you're on the defense, you got the benefit because you don't need to get all 12 to like your guy, right? You just need to have one or two to get in the room and fight and say, I'm not going with a conviction. So that's what's interesting. I think, this is not one of those cases where it was all or nothing. The prosecution tipped the scales. If it was a civil case, I'm with him. I mean, I think he probably did it. They convinced me by a preponderance of the evidence, but that beyond a reasonable doubt stuff, that's where, the defense lawyer may be right. They wanted a conviction. There's only way to get a conviction was to convict him. It's not appealable because of that. That's something that's well within the jury's discretion. Just interesting. We've seen cases that are much more clear-cut than this, but that doesn't mean that it's a bad verdict.
Michael Bixon, when you talk about reasonable doubt, and I would always do this in my trials, and I would say, listen, because the defense would have some alternative crazy theory about what happened, and I'd go through them, and I'd say, well, is that reasonable? Does that sound like a reasonable explanation for what happened here? I mean, does it sound like a reasonable explanation that Joan Harmon, and again, this is according to Kit Martin's own testimony, would mastermind a court-martial against her, and she's the one who gave the laptop, she's the one who, according to Kit Martin, made up all these charges, masterminds a court-martial, and then undermines her own plan to take him down by killing the key witness against her ex who she hates? Why would she do that? Why would she kill Cal Phillips? It makes no sense. He was the key to the court-martial, Michael.
Vinny, it's a theory, all right? It's a theory. And you know why it's a theory? Because the state's case was so bad that this was the best they could come up with. That Kit was the best suspect, and their case was littered with reasonable doubt all throughout the case. I mean, I'm blown away by this verdict.
Give me a reasonable explanation for what happened here.
Vinny, I don't have to. It's the state's job to do that, and they didn't deliver on it. The jury wanted to convict someone, and they saw someone sitting in the chair, and they convicted him. It's that simple. It's the wrong verdict.
Yeah.
And also remember that he was also charged with the counts of complicity. And the judge dismissed those counts. Those counts didn't even go to the jury because the judge said there's not even enough evidence here for that. And he just let the murder counts go. And, because they didn't like him, I think that's why they convicted him.
Or maybe because he murdered three people?
Vinny, what trial do you hear a prosecutor say that the caliber weapon used in all three deaths could have come from guns owned by the defendant, or they couldn't necessarily exclude the Glock? But that's something you hear from a defense attorney, not a prosecutor. This is the argument that she's delivering to a jury in a murder trial? Are you kidding me? It's terrible.
The problem is you got 12 people. I understand there's reasonable doubt, but they got 12 people to go with it. That's they carried their burden.
All right.
Well, they got 12 people to agree to it.
I think that they're going to, in appeal, they'll argue that the verdict was against the weight of the evidence. I don't know what else they're going to put forth.
It's a tough one.
Oh, there might be some other issues. There might be some other issues. Tom Griffiths, again, he's a great criminal defense attorney, by the way. Did a great job. But here he is talking about Joan Harmon. Take a listen.
I think they took the Fifth Amendment and refuse to answer questions and refuse to come to court because they're involved in this case. I think the reason someone takes the Fifth Amendment is because there is criminal activity that they have engaged in that they don't want to answer questions about. And so that's what I believe occurred. So Joan Harmon knew that she would either have to lie or she would have to tell the truth about her involvement in this case, and she didn't want to do it. I'd like to point out that Joan Harmon's connection to this case is apparent and known by everyone who investigated. Nothing is more telling than the fact that Joan Harmon's boyfriend was so well known and considered to be potentially part of the case that his own brother, who was on the sheriff's department, was removed from the crime scene on day one because of a potential conflict of interest. So it isn't something that we as defense attorneys came up with. This is not a scam. This is something that the police, way before any defense attorneys were involved, on day one said Joan is potentially involved in this.
All right, Michael Bixon, I want to start here. Tom Griffith said that when someone invokes their Fifth Amendment right, it's because they've engaged in criminal activity. So should I take from that when these defendants don't testify that they've engaged in criminal activity? Because that's what he's saying. Joan Harmon took the Fifth because she's, when someone takes the Fifth, it's because they've engaged in criminal activity. Criminal defendants at trial take the Fifth all the time. They don't testify.
Yeah, but again,
is that because they're all guilty?
It as a blanket statement, Vinny, look, if you look at it as a blanket statement, I absolutely don't disagree with it. Well, I absolutely do disagree with it. But, in a particular situation, yeah, of course people use it because they don't want to be charged with a crime or to protect themselves from an overbearing government trying to use their words against them. Of course. But as a blanket statement, no, I don't agree with that.
Okay. I don't either. I'm just, I just found it interesting. All right, let's talk about Joan Harmon. Professor, do you think that she should be investigated? Do you think she wouldn't testify? She took the Fifth. The prosecutors believed there were other people involved in all of this at one point. Do they have an obligation, do you think, ethically, to investigate Joan Harmon, even though they've got a conviction here on Kit?
Well, the fact that they have a conviction makes it much less likely they're going to spend the time, effort, and taxpayer money on it. Do they have an ethical obligation? Sure, they've got to look. But do they have the obligation to spend taxpayer money to go after somebody else? They've got the same analysis they always have. Can we get a conviction? Is it a winnable prosecution? So if they do an investigation and they don't get anywhere, they don't have a duty to go after every single person that might have done something wrong. They've got a duty to try to convict the people they can convict. If they think they can get a conviction, then they should prosecute. Right now, I think they feel lucky to get this conviction more than in some other cases. They may leave well enough alone.
Renee Hill, so is it up to the defense here to spearhead an investigation to uncover what they believe really is the truth here? I mean, you should kind of do that before the trial, but apparently they didn't uncover everything they needed to uncover because if you put the two cases next to each other, Joan Harmon and Kit Martin, don't tell me there's more evidence against Joan Harmon at this point.
Right. I mean, if the defense thinks that there's possibly some evidence that wasn't disclosed, if there were some sort of violations, Brady violations, things of that nature, they can have their investigators go out and look for more and see if there was something that the prosecution knew about that they didn't turn over. But like Randy said, the prosecution has already gotten their conviction. So it's very unlikely that they are going to do anything else in this case. And the defense may not have anything else to find with this young lady.
Yeah, and looking forward, Michael Bixon, I think there were some issues in this case. The statements that were made by the victims saying Kit Martin is trying to kill me, that's, I think, something that an appellate court's got to look at. I think you have to look at the fact that Joan Harmon and her son took the Fifth, even though they were subpoenaed and to be called as witnesses by the defense here. So there are some issues, right, that will make the appeal at least somewhat viable, and a court's going to have to look at it.
Well, I mean, I think that there's more than just some issues here. I think that when you look at this case, it violated every concept of criminal justice that we have out there. you're going to be very hard pressed to find someone across the board, prosecutor, defense, who looks at this, who looks at the weight of the evidence, who looks at, throughout the entire trial, everything that was said and given and shown, and say, oh yeah, absolutely, beyond a reasonable doubt, the state met its burden. There's no way. I mean,
But did those
even as a
issues go away
prosecutor-
because this man testified, and doesn't everything
No,
come back to he
Vinny,
testified
no.
and he lied to us? We didn't believe him, and that
No,
adds to the evidence.
Vinny, just because you don't like him on the stand, just because maybe you don't necessarily agree with him on certain things, doesn't mean that the state has met their burden. They're two distinct and different things. And I think you have to look at what the state has proven and what they have not. And it's clear, at least it should be clear on both sides, that the state has not met its burden.
Are
in
you
this
saying
case.
this should have been a directed verdict? Is that what you're saying?
Absolutely. 100% it should have been.
All right. That's why we bring them on, folks. They all have their opinions. We'll see. And again, of course, Court TV will keep track of what happens with the motion for a new trial, which they'll lose, and the appeal, which we'll see what happens. All right, when we come back,
They'll lose.
What, Renee?
You said a motion for a new trial, which they'll lose. Is that what you said?
Right.
Okay.
Hey, I think
How
they
many
will.
wait. How many judges at the end of the trial have said, "Oh yeah, I really messed up. I'm going to give you a new trial"? Come on.
On this verdict, they might.
Yeah, but the
Vinny,
problem
the
is
verdict
you
was
didn't
against
you didn't
the
direct
weight.
you didn't direct the verdict, and they got it guilty. So the judge is sort of saying, "See, I'm glad I didn't direct the verdict because I didn't see what the jurors saw."
Exactly.
It's a hard one to overturn.
Thank you, Professor. All right, when we come back, there is another trial taking place down in Tampa, Florida. This one, it's a horrific case. A woman and her daughter are murdered, and the defendant is her boyfriend, the father of this little girl. He's representing himself, and today the star witness for the prosecution took the stand. 11-year-old, his son, who's also a victim, but amazingly survived. We'll take a look next.
Remember I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all. And the evidence will show that my son said my dad shot my mom. It's the correct statement if you want to cite statements. If he even said it.
That is Ronnie O'Neill representing himself. He's facing a potential death penalty for double murder of his girlfriend and their daughter. Star witness taking the stand in the case, his 11-year-old son, who was there when it all happened. So, as the star witness, yes, he testifies about what he saw, what he remembers from that night. But then his father has the opportunity to cross-examine him because he's representing himself. Our great affiliate, WFTS in Tampa, has the story.
Do you remember the night when something bad happened to your mother and your sister?
Yes. State Attorney Ron Gale wasted little time getting into details with Ronnie O'Neill III's son about what happened to his mother and sister in 2018. He was just 8 years old at the time.
Basically, I was sitting in my room and I saw my mom and my dad arguing.
He went to the back bedroom and saw his dad holding a shotgun, he told the state. Shortly after that, he saw his mom run into his sister's closet and hide. He was in the living room when he recalls O'Neill telling him to come in and help him kill his mother.
I went in the room and then he handed me the shotgun and helped me shoot it.
But he can't remember if the gun went off while he was holding it. He told the state he saw his dad kill his sister, and then he says O'Neill III came after him.
I was laying on my stomach, he had his foot on top of me and he was holding me down.
He says his dad attempted to light him on fire, but can't remember much more after that, besides walking out of the garage.
And I just remember going to someone and saying, that my dad killed my mom, and then I got like a mask put on me, and then I don't remember anything from there.
O'Neill III was eventually able to cross-examine his son.
It's good to see you.
On several occasions, O'Neill questioned his son on details.
Did you see me beat your mom?
No,
Did you see me shoot your mom?
no.
Which he seemed to be using as a way to prove it wasn't matching up with what the boy said previously to detectives and attorneys in 2018.
And she asked you who was getting the shooting, and you said, your mom. And she said, okay, did you see it? And you said, I heard it and saw it. Do you remember saying that to her?
No, I do not.
Judge Michelle Sisko noting on the record,
Mr. O'Neill appeared to be in command of the facts and knew the points that he was trying to get across, and I feel that he did so competently.
Unbelievably bizarre what's taking place in that courtroom, but it has to. Let's bring in our think tank. Michael Bixon, I mean, they have to proceed this way. He wants to represent himself. He's competent. So he's the one who's got to do it.
Yeah, and it's a tough line for a judge to walk between, being competent, being able to represent yourself, and sort of, figuring between those two rights. I mean, obviously you want, to have a fair trial for both sides, but on the same side, if you have someone who you might feel is incompetent or not prepared to go forward on a case where their life is literally on the line, it's something to seriously consider. And, he's made a number of comments to the court that are, concerning at the minimum. And I think that, we should all be concerned when somebody's, about their execution is on the line and their competence is being questioned. But that being said, he hasn't done a terrible job of this trial other than some, awkward delivery.
Randy, the bottom line here is if you don't allow him to represent himself, then you're going to have a problem on appeal.
True. And not only that, this defendant, he's not dumb, right? He's prepared. He is in control of the facts, and he's getting away with something that lawyers can't do. When he does his opening and he says the evidence will show, we all caveat it when we tell our story. You can say almost anything you want when you say the evidence will show. He's basically saying the evidence will show that I did not do it. He's getting to testify during his opening without being cross-examined. He's getting to say exactly what he feels, and he's the person that's being accused. He's not taking the witness stand. He's just saying, I didn't do it, I didn't do it, I didn't do it, and no one's going to be able to show you otherwise. He's taking advantage of it. He's doing, by all intents and purposes, he's doing a good job for a pro se, a non-lawyer. He's a little bit loud, he's a little bit offensive, and I think jurors might be a little bit put off by that. But he's confident. He believes he's not guilty. That's clear.
Renee Hill, it's a death penalty case. And if the jury convicts him, there's a lot of evidence. And if the jury convicts him, we get to the penalty phase. How is that going to work?
Yeah, I think at that point, he may come to senses and have his shadow counsel or counsel that's seated beside him help him out in that penalty phase and make the arguments on his behalf. It's really not a good idea, obviously, for him to be representing himself, despite the fact that he has the constitutional right to do so. But, it's very damaging. And should he get convicted, it's going to be even harder during the penalty phase here. And this case is shades of the Colin Ferguson case from years ago.
Absolutely.
Yeah, and what the witnesses in that case had to endure on cross-examination by the person who shot them, it was just horrific. And I see that unfolding here in this trial as well.
And we have to, unbelievable job by that 11-year-old boy. The ability to sit there. He was in a remote place, but to be able to answer those questions and remember things from when he's 8 years old and to persevere through all of this, our thoughts, our prayers are all with him. Special young man, and we wish him the absolute best. All right. When we come back, we're going to take you on the docket, folks. Don't go anywhere. On the docket tonight, a case that has a very familiar fact pattern. Very familiar for anyone who's been watching trials through the years. It's a story of a young mother who has a daughter, and the daughter goes missing, but the young mother doesn't report the daughter missing. As a matter of fact, no one in her family reports the child missing until a little bit later. And then when finally a report is made, it's not made by the mother, but by one of the grandparents. And then when the mother is questioned about all this, about where's your child, she allegedly makes up some stories and lies about it. Says, oh, I know who has the child. Does this sound familiar to you? It should. This one, though, is taking place in Tennessee, and the child's name is baby Evelyn.
Evelyn. Hi.
15-month-old baby Evelyn Boswell, a beautiful blue-eyed toddler from Tennessee, being raised by her teen mom Megan, goes missing with an Amber Alert issued on February 19th, 2020.
We remain committed and continue to do everything possible to find out what happened to Evelyn. And as always, as soon as relevant information and accurate information, I want to really reiterate that. As it comes to us, we will get that out as soon as possible, okay? Anyone with relevant information concerning Evelyn's whereabouts are asked to call 1-800-TBI-5.
But that Amber Alert was not issued on the day she went missing. Baby Evelyn actually disappeared in late 2019. And her mom said she didn't report her missing because she knew the person who had her and did not want them to take off with her.
I've told TBI where to find her in Mendota. My mom took her to a campground and a silver camper, and if they don't go tonight, I'm gonna go find her myself. Just bring her back. I just want her back, that's all I want. I've been so long without her, and I know a lot of people are like, oh, why didn't you report it missing earlier? Because my mom threatened me, and I just want her back. That's all I can think about is how much I just want her back.
But investigators were not buying Megan Boswell's stories.
Aware that we've received a number of conflicting, inaccurate statements from the mother, Megan Boswell, Evelyn's mother.
What happens next is a strange string of events. First, Evelyn's grandmother, Angela, is arrested with her boyfriend in North Carolina for possession of a stolen vehicle, which was part of the Amber Alert. Then Evelyn's mom is arrested in Tennessee for making false statements.
We determined that some of the statements Megan Boswell provided to us were false. Many of the false statements that Megan made delayed our investigations and also impeded our investigations on trying to find Evelyn. As a result, she has been charged with false reporting.
Got any questions about that? Ms. Boswell, got any questions about that?
Then big breaking news. 2 weeks after Evelyn was reported missing, a toddler's remains are found.
This evening, we received information that led TBI agents and Sullivan County detectives to a property belonging to a family member of Evelyn's mother in the 500 block of Muddy Creek Road in Blumpville. During the search, investigators discovered human remains believed to be those of a 15-month-old girl. The remains will be sent for an autopsy and a positive identification.
So now the question is, what happened to baby Evelyn and who is responsible? Reminds me of another case, really does. Let's bring back in our think tank. Still with us, Renee Hill, Randy Kessler, and Michael Bixon. I'm hearing a little echo. Okay, there we go. Good. All right, so I'm looking at this case, and I'm wondering, is it possible that in Tennessee we're going to find 12 jurors who will listen to evidence involving a mother whose young child goes missing and doesn't report her missing, doesn't do anything about it, yet they'll send her home not guilty? Renee, is that possible? Could that possibly happen?
Anything is possible, Vinny. You know, there are cases where it has happened, right? But, you know, this is another one of those cases that's going to be really difficult. The child cases, are really, really hard to listen to. And it's really going to depend on how this case is presented. If the prosecution has everything that they need, and if the jurors really pay attention, they'll do their job. They'll do their job and let the chips fall where they may, as we say.
Michael Bixon, a mom's child goes missing. A beautiful little girl like this goes missing. She doesn't say anything. She doesn't do anything. Then when other members of her family notice that the child's not around, hasn't been around for, perhaps a month or two, they call investigators, and then all of a sudden mom says, oh yeah, I know exactly where the child is, and the child's not where she says. The child is not there. It's a very provable lie. I mean, does an innocent person whose child goes missing, right, and disappears, does an innocent mom lie about it? Does a mom not do anything when your child goes missing? Like, what could possibly be another explanation for what happened to little baby Evelyn if, in fact, her mom's not responsible?
Well, there's no question that it looks like she was lying at some point. The question is, what lie was it? And if they're all lies, there's so much that we don't know about this case. I mean, is it possible that she didn't kill her child? Yeah. Is it possible that she wasn't involved in the murder? Of course. Problem is, we don't really know what happened here. We know that she lied about what happened after her daughter went missing. But does that mean that she necessarily killed her daughter? No, there's a difference between those two things. And I think we need to note that difference.
Okay. Randy Kessler, what are the reasons? Why would a parent lie about where their missing child is? Why would a parent not say anything about their missing child who then ends up dead if they are not somehow connected to what happened to that child?
Well, how long do we have, right? There are hundreds and hundreds of reasons people lie. They're scared about some consequences.
Scared
that are
about
worse
what? Consequences
than
for
being
what?
Okay. It depends on who is pressuring them. It depends on what the mother had on her. It depends on what other people might have been involved that say, if you implicate me, you will be dead. And that's worse than a jail sentence. There are a lot of reasons to lie, but you're right. It's not good to lie to police, but you better be really scared of something else if you're going to lie and jeopardize your own safety, your own liberty. It's not looking good when you lie, but there are reasons that people lie, and there are legitimate reasons for your own safety, the safety of your child. Someone tells you, I'm going to murder your child unless you lie, then it ends up happening, and then what do? Do you admit that you lied? Do you cover up the lie? It's a never-ending story. There are reasons that people lie. You shouldn't do it. This is what happens when you do.
And sometimes when people are guilty, they lie too, when they did it.
Renee
Hill. Renee, let me ask you, Renee.
Yes.
Does the defense in this case need an alternative explanation? Because this is the child's mother, okay? There's no, that little baby, that beautiful little baby relied upon that teenager for everything. For everything. That's her mother. There's no dad really in the picture here. It's her and her child. That child is dead. That child was found dead. That child wasn't reported missing until grandpa called police. Why do they need to come up with an explanation for her actions, her inactions, and what could have happened to this child?
Listen, it's always nice to have another alternative to present to the jury as the defense. However, we don't have an obligation to do that. It's the prosecution that has an obligation to prove the case beyond a reasonable doubt. That's what they have to do. And if the defense has something that they can say about these facts, why she did this, why she didn't make the call when she should have, all of those things that we know about right now, if they have an explanation for it, sure. And they can present it to the jury in a way that the jury will understand it, then they should do that. But at the end of the day, they don't have to do that. She's saying she didn't do it. That is sufficient. Now the prosecution has to prove that she did.
Okay, and I can confirm tonight that the defense has not requested a change of venue to Pinellas County, Florida. They have not done that, and they can't because they're in Tennessee.
That's funny.
All right.
That's funny.
When we come back, folks, time to hear from you. Our 13th juror posted some shocking video, and it's heartbreaking and shocking at the same time. A mom is in court. There's a trial taking place for the man that she believes and prosecutors believe murdered her child, and the judge dismisses it. A directed verdict. A directed verdict. Jury doesn't even get to make a decision. And at that moment, mom charges at the defendant. We've got the video. Your reaction when we return.
Come here. Go back. Get back. Get back. Get back. Get back. Get back. Get back. No. Get back. Okay. You all right? Huh? Your body cam's on the ground.
I won't clear. Don't kill my baby. You know he killed my baby. And that bitch didn't say that. She said she was 75% sure of his son and 100% he was the shooter. Y'all crazy. Stop. Y'all gonna do this.
Calm down.
Y'all gonna do this.
Hey, calm down. Calm down, breathe. Breathe.
I don't know who's this.
Breathe. Breathe. You want to get up? You want to stand up real quick? Yeah, try, man. Ready?
Yes.
Ready? Take some deep breaths, all right? Calm down. I know. You ready?
Yeah.
You ready?
Yeah.
Okay. 1, 2, 3. All right.
It's heartbreaking. And let me give you the backstory. That mother was in court. It was sort of a modified courtroom there. There was a trial going on for the alleged killer of her child. But the judge dismissed the charges because the judge believed the evidence wasn't there. There were eyewitnesses, but no one could positively identify the defendant as the shooter. The defendant, Tevin Biles, the half-brother of gymnast and Olympian Simone Biles. And judge dismissed the case. And at that moment, you know, you can see the combination of heartbreak, anger, and frustration all coming out inside the courtroom. Posted this. Got your reaction. We'll begin with our 13th juror comment of the day coming from Cynthia. Cynthia says, I think we all know that our justice system, such as it is, doesn't always bring justice. Unfortunately, the judge felt the evidence was not there to proceed. My heart goes out to this mother. Renee Hill, it's a difficult situation. You lost your baby,
Absolutely.
You lost your child, and now you're going to walk out of that courtroom with no sense of justice.
Absolutely. You know, you have to feel for her. You know, her child is gone. She believed that the person they had in custody, charged as the defendant, was the actual perpetrator, and now he's going free. And she has no closure whatsoever. It's extremely difficult, and you know, it breaks your heart to see it. It really does.
Next comment comes from Anna tonight. She's a grieving mother, and I hope none of us never feel that kind of pain. However, with that being said, we cannot behave like that and threaten to kill another person. I completely understand where her anger is coming from, but she won't do any time. They'll probably leave her in there for a couple of days to watch her, and they'll most likely drop any charges that may be pending against her. But I'm sure she'll be expected to apologize for her outburst. Randy, what, if any, action do you think should be taken against this mom?
Oh, I don't think there's going to be any action taken. She's already been handcuffed. She's been put away. She's doing what a lot of people want to do, and I'm surprised it doesn't happen more. If she's contrite, if she's remorseful, she apologizes, how are you going to get a conviction? You're going to take this case to a jury trial? No way. I think she'll get a slap on the wrist and she'll apologize. She's not doing this again. That's what we worry about. It won't happen again.
Teresa tonight, writing, if he were truly the murderer, I would feel exactly the same way she did. But if you read the case, there was not evidence to prove he was the guilty party. I would be just as upset if my child got life in prison for a crime they did not do. They will gather more evidence and continue the investigation. But Michael Bixon, if they continue the investigation and find evidence against this defendant, he can't be tried again.
That's correct. I mean, unless it was for something completely different. But no, I mean, at this point, the case is over. He's walking. That's it now. She could try to sue him in civil court if she hasn't already tried, but that's a totally different matter.
That's an interesting idea. To get some sense of justice. Lisa tonight, too bad Kid Martin's judge didn't obey the law like this judge did. Death is sad, even sadder when the wrong person stands trial just because someone's got to pay. Renee, I'll give you the last word on Lisa's reaction to all this.
Vinny, I think that you know that at least Michael and I agree with what she said. We said it before and we're going to say it again. The evidence wasn't here. The prosecution didn't prove this case beyond a reasonable doubt. Despite the fact that the jury said they did and they convicted, the evidence wasn't there.
And our final comment tonight from Lane, that happens a lot. Grieving families look for justice and someone to target and blame for their pain. It is completely understandable, too. Randy, we only have like 15 seconds here, but also some compassion by the deputies.
Yeah, but and also that makes Renee and Michael's point that, you know, juries sometimes do get it wrong. But yeah, good for those deputies. All the bad stuff we see about cops and video cameras, they handled this appropriately. They were concerned. They did it right.
All right. And Renee Hill, Randy Kessler, Michael Bixon, always great to have you on the show. Thank you so much. We will see you again very, very soon, perhaps next week.
Thank you.
Yep.
Thank you.
All right, folks, that's it for us here. Our gavel